in regards to, it's wintertime. I don't know about you guys. I got a call from a tenant in a house we had just renovated, just moved him into in November. This was Christmas Eve, about 3 o'clock in the afternoon. The tub's not draining and the water line to the kitchen sink isn't working. Instantly, I'm like, frozen pipes. And who's gonna come out here on Christmas Day if this pipe bursts and floods my basement? Nobody wants to deal with that kind of problem. What we're gonna end up doing, with Derek not being able to make it tonight, we're going to shoot a video and post it to the Facebook page. So this is a dual-fold benefit here. He's gonna talk about some tips and some best practices so that you can be best prepared to prevent that situation in any rental homes, as well as how do you handle it if you do have an issue. So we're dealing with heating and with cooling issues in the wintertime. That's very important for all of us. Who here has ever had a pipe burst in a house?
Christmas Eve.
It is the worst. Because you not only have to deal with the pipe itself, it's the water damage afterward. And so the best you can to prevent that, avoid that at all costs, we want you to reap the benefit of proactive support on that. That being said, I'm going to keep it short, sweet, and simple tonight. Hope you all enjoy. And I know we're in for a treat with our main presentation. But I definitely want to make sure those who have not. Now, I'm going to ask this because I don't know. And you're next up?
Yeah,
sweet. I'm going to ask just because I want to be real practical about it. How many people here have been a member for at least 3 years? How many have been a member for at least 1 year? How many have not become a member yet? So my direct and explicit appeal tonight is that you give consideration to the value of the relationships you're developing here in this room, the keys and insights that you're going to gain, to allow that to be the inspiration that says, let me quit being an over-analytical or frankly just cheap landlord, and let me make the investment of $200, whatever the cost is now, to become a member so that I can be fully vested in all the benefits, the relationships, and the resources that are here. We're glad you're here. Continue to enjoy, continue to soak up the knowledge, and we welcome what you have to contribute to our organization. Without further ado, we're going to go ahead and, I don't know if Ed's going to come up first or if I'll just go ahead. You got that, Ed?
Oh, yeah.
There it is. All right, bring on the baby whisperer here.
Thank you. All right, and so before we introduce Craig, I do want to plug Terry Picard, Serve Pro. Terry, you want to stand up briefly?
24/7. We actually were at the Genesee Valley on Christmas Day for about 6 or 7 days. So yeah, if it does, I got called out for some stuff on Christmas Eve day. Our crews, they were out there soaking up water on the 25th at the Valley. So, you know, anything like that, we can take care of it. And we're the phone call we hope you never have to make. And ice dams, that's what we're telling our people now. You see those ice dams, call an expert out there to help get rid of those, because if it's gaining there, it's getting under your roof, and when it melts, it's not going to be pretty. The icicles look real nice, but they're not good for the roof.
Terry, what would it cost to send a couple of guys out with the water extracting machines for say 2 hours on a Sunday?
Every job is different, but anywhere from 500 to 5,000. I mean, it really, until you get out there and realize what you're doing, it's hard to quote it, but somewhere, I know that's a very big ballpark, but you know, if it's actively, you know, we want to get that water out of here as quick as possible, especially if it's, you know, if your heat's on in the house, obviously, because that's when stuff starts growing and we don't want it to be growing. Because that opens up a whole other can of worms. Fortunately, if it's a water leak, it's easily fixed without having to go through all the biohazard type stuff you would get with like a sewer backup. But it still does take, you know, I mean, there's damage, it's got to, you know, sometimes it's a matter of just sucking up some water in carpet. Other times, it's cutting 3 or 4 inches high in the drywall all the way around. So it really just depends on what's, you know, the size of the job and how big. Thank you.
Thank you, Terry. All right, so next thing, Craig Federline. He is a board member, attorney, CF Legal, here to talk about estate plan. Trying to be fancy.
All right. Well, thank you for allowing me. Thank you for allowing me to speak with you today. My name is Greg Federline, law firm of CF Legal PC. We're located at 302 East Court Street in Flint, Michigan. We have 4 attorneys in our office. Josh over here is part of my office, an associate that works closely with me on estate planning and also funding of estate planning. I also have Rick Hetherington in my office. A lot of you guys might know him as a retired Flint police officer of over 20 years. Now does criminal defense, DUIs, and family law. Obviously, I originally cut my teeth with respect to working as an attorney, as a real estate attorney. My uncle owns over 300 apartment buildings in the Bronx, and that's how I started with at least having real estate as my initial interest in the field of law. I've been practicing now since 1996, so starting to get up there in age, over 20 plus years. And the area of practice that actually I enjoy doing is estate planning and also probate litigation type work now. Most importantly, when we're talking about estate planning, we're talking about there are certain keys to estate planning for landlords. One is we're concerned about losing control or access to your assets. Okay? Number 2, not knowing the law or who your creditors are, not working with qualified professionals, and not knowing the real costs. So first and foremost, I wanted to talk a little bit about the differences between why you need powers of attorney for financial, why you might need a trust, why you might need a healthcare power of attorney, and how those are used in estate planning. So when we talk about estate planning, the first thing I do, and I gave you a lot of handouts, you do not need to look at it right now, but in there's a personal financial information sheet. You say, oh wait, you're my lawyer, why do you need to know about all of my assets? Well, in order to do a proper estate plan, we need to know what your assets are so we determine what's best for you. Okay? And each person has a unique estate plan. Now, today I'm going to try to focus on landlords, people that may own businesses, and vice versa. So, first, it's important to understand the type of assets that you own in estate planning and how they're held. Because you can say, well, I don't need an estate plan. I have my will, I have my life insurance policy with State Farm. My life insurance policy, I listed my 2 kids as beneficiaries. My 401k, my IRA, I have beneficiaries on those policies. I don't need you. I have a bank account. You know, my wife's got power of attorney at a bank account, or she's joined on the bank account. And I name my kids as TOD or POD beneficiaries. Like if you go into a bank, you can name a beneficiary on your bank account now for your checking and your savings account. I don't need you, Mr. Federline. I have a house, you know, it's joint with my wife. There's nothing I need to worry about. Or a cottage up north. I'm just going to put it in all my kids' names. Or I have a business. So now, the key with understanding estate planning is how and why you need a trust. Okay? A trust is basically a contract, and it determines during certain stages of your life what you need. Okay? A trust, the standard form that you look at Susie Orman or you hear on TV, is your revocable trust. You're entitled to all the money. You don't need any new tax ID number. It's all under your own tax ID number, and it controls your assets for you while you're alive. I like to explain things like with the little red wagon. When I was a kid, I had a little red wagon, and I would walk it around and I would put all of my stuff in the little red wagon. Well, I had my G.I. Joes, my sister had my Barbie, sand pail, everything that mattered to you as a kid was in that little red wagon. Well, that's what you need to think of a trust as. A trust is a little red wagon, but as adults, we have larger stuff, okay? And the goal in the trust is to put everything into that wagon. So you can easily manage it. Now, when you set up a trust, you're the grantor or settler of the trust, you have control of the handle of that wagon. You're in control of all the assets. You can say who you can sell it to, if you want to sell it, you name it. You're in full control of it. You're entitled to all principal and interest of those assets. Okay? But what if you get injured? What if you have dementia? What if you fall, obviously as a kid? You can't hold the handle to that wagon. Well, that's your successor trustee of your trust. That's the next person that you name in line to take over your trust when you're unable to carry the wagon because of incapacity or some other reason, or death. When you die, that successor trustee picks up the wagon, controls the assets in the wagon, and distributes it to whoever your beneficiaries are. Very simple, right? It's not a complicated thing. Now, do you have asset protection? The first question everybody asks me, do you have asset protection with a trust? Not really. Okay? Now, is it a little bit harder for a creditor to, if they got a judgment against you, to control your asset if it's in a trust? Yeah, banks may not freeze it. It might take a lot of work for the creditor to try to access the trust or to file a motion with the court to make the trust liable for the asset. So it does create a barrier. But when you're entitled to the principal of that trust, the money, and you're in control of that money and you're entitled to all the principal of that money, like the bank account, you can write a check to yourself anytime you want from that trust bank account, then a creditor should be entitled to that account too. Okay? So we've also developed something called an irrevocable trust. Okay? Or a Medicaid asset protection trust is a very popular term, where you can put assets into an irrevocable trust, but you're not entitled to the principal of that asset. That's the catch. You can be entitled to the interest, but you're not entitled to the principal of that asset. Now, for purposes of Medicaid look back, they're looking back like 5 years on transactions to determine whether you qualify for Medicaid or if someone ends up in a nursing home. So we always like to talk about irrevocable trusts, but the people that typically hire me because they're getting 65, 70 and they want to protect those assets, either just want to make sure that they're manageable and they don't go into probate court and get slowed down, okay? Or they want to protect those assets in case they end up in a nursing home and they put them into an irrevocable trust. Now, but the most important question is this, is we can have asset protection upon your death. So upon your death, if you look at this little sheet that I have here, I have a black line, goes right here. And you can have asset protection for your kids. So that's called what I would call a sub-trust. So you start with your trust up here, and upon your death, let's say you have 2 children, child 1 and child 2. So upon your death, child 1 trust gets funded and child 2 trust gets funded. That trust is 100% protected with the trust that I create. They name what's called a co-trustee of their choice, and that co-trustee has no power because they can fire them pretty much at any time they want. They can write the checks for principal to themselves anytime they want. They're entitled to all the interest of the trust. They can invest the assets in that trust, but it's 100% protected from creditors, 100% protected from divorce by that particular child, and upon their death, that money can automatically go to your grandchildren. So when it comes to someone hiring me for a trust, yes, we want a revocable trust to organize our assets, but more importantly, we want a sub-trust to protect our kids and them. So that tells you a little bit about a trust. Now, does anyone here know what a power of attorney for financial is and what the difference between that is and a trust? Let me explain. A power of attorney for financial is only for those assets that are in your name while you're alive. So it's like the trustee of your trust. You name a power of attorney for financial of, let's say, I name my wife Nancy as power of attorney of my finances. Well, when I sign that power of attorney, okay, she has and can maintain control over my checking account if it's in my own name. She can handle my real estate if it's in my own name, with questions by title companies. Okay? She can handle my investments, my beneficiaries. She can even create a trust and create an irrevocable trust to protect those assets for me. We can put that into a power of attorney for financial. Okay? And it's only for those assets that are in your name. So the power of attorney for financial works with the trust. So let's say you prepare the trust with my office, you go ahead and you create a new bank account, you have some more stock, and you have another investment. But now you're disabled and you're in the hospital. Wife hires the lawyer, realizes, oh my God, Craig didn't do his job, he didn't go back to the lawyer and fund his trust. We call that trust funding. So, with her power of attorney, she can take power of attorney and she can fund the trust with any assets that I accidentally left in my name so that they don't go through probate court. Because with a trust, we avoid probate. Now, anytime I do an estate plan, not only do we do a trust, but we also do a will. And you say, why do I need a will if I have a trust? You only need a will, I call it a CYA, cover my ass, all right? And the reason is this. I created an estate plan for you. We go through all of these assets, and I told you, you have this stock over here, or you set up an LLC over here, or you bought a cottage and you left it in your own name. When you died, you didn't put it into the trust like I told you to, or because you just failed to follow up. We all make mistakes. So what you would then have to do is go file in probate court with my death certificate if I died. Okay, whoever I name in my will as the personal representative of my estate is the same person who normally is the trustee of my trust. They probate the estate, and all they do is they pour over whatever assets are in the probate court, and we pour it into the trust. So it basically makes a two-step process. Well, isn't the purpose of the trust to have a one-step process, an easy one? It is. But sometimes we have to go through a two-step process because someone forgets. But remember, those assets still go into the trust. They still get protected with Kid 1 and Kid 2. All right? Now, years ago, we used to do wills where if you had 2 kids and let's say they die and you're like Ed Constable and the kid's 5 years old. Okay? What happens to the assets when you go through probate court and you have a 5-year-old child? Well, you can create what's called a testamentary trust in the will, which I used to get paid extra money to do. You put a trust inside a will because that's cheaper than a trust. But then that requires court approval and court accountings each and every year. So it really doesn't make sense to do that. Or if you don't have a testamentary trust, the court requires you to open up conservatorships for each kid to protect their money, which limited in the type of investments that you can do. And if, let's say, you want to get the kid some braces, or you want to get the kid a new car when they're 16, you have to petition the court for approval, and guess what? That judge doesn't want to release that money. So the goal of a trust is to avoid court involvement in our life. Okay? That's one of the really keys to the trust. Now, also as part of our estate planning, we do what's called a patient advocate form, living will, medical power of attorney. You will hear these forms used interchangeably, okay? But basically, if you're in the hospital and you're unable to make medical decisions, we call that incapacitated. 2 doctors certify that you can't make medical decisions. Then what we do is, after 2 doctors certify you can't make a decision, then the person who you named in your patient advocate form, let's say my wife, has the right to fire and hire doctors, and then she can actually stop the artificial delivery of food and water if I'm not going to make it, for example. But to give you an idea, there was I don't know, everyone's probably heard of the Terry Schiavo case.
Yeah.
That's really the key case that started all of these forms. And in that situation, we had a situation where a woman, basically she was incapacitated, a persistent vegetative state, 99.9% brain dead. Okay, her husband wanted to let her go, but her parents said no, there was a miracle chance that she could recover. They actually found a doctor, not a treating physician, that said sure, there's a miracle chance she could recover. Went through the courts for 10 years while she was on life support. Obviously, at that point in time, she did not have a medical power of attorney. Today, your own husband or wife cannot tell the doctors what to do. I have had to go to court for emergency guardianships because there's no one with authority to tell the doctors what to do. That's called, and you're going to spend $1,500 to $3,000 easy in a guardianship proceeding and or a conservatorship proceeding to control the money. So the guardianship proceeding determines care and the health care decision and very small assets. And a conservator is a person who handles the financial of a person through the probate court only when that person has been determined to be incapacitated by the court. It requires hearing, requires notice of certain people, and it doesn't necessarily follow who your choices are. It's determined by who your heirs are. The problem is we don't know who our heirs are. Okay? We don't know who that person is that's going to be living when we die. We've all found with COVID and circumstances with life that we can't predict when it's going to happen or how it's going to happen. Okay? I am that person on the other side of the wall. I kind of think of myself as like that Oz guy sometimes. And we can see what's happening and we've seen all the problems that can occur. And most of them are unpredictable. We don't know if your spouse is going to be surviving you or your children are going to die with you in a car accident and we have to preserve those assets for your grandchildren. We just don't know. Okay? Another situation is, remember how I talked about that life insurance policy? I actually have a story for you. And this is why we talk about trusts and irrevocable trust and things like that. I named my spouse as beneficiary of my policy, right? We're in a car accident, I die. I have a $2 million policy. Okay. Who's the beneficiary of my policy? My wife, right? My wife gets $2 million even though she caused the accident. She's not that great a driver, okay? Isn't she going to get sued for hitting the other driver? Or the bus that she hit? Yes, she can get sued for that $2 million. So what good was that policy with my spouse as the beneficiary if she was the cause of that accident? That's why we named the beneficiary of our life insurance policy the trust, with creditor protections attached to it. There are little things that we see behind this wall that you don't realize. Another reason why I told you about powers of attorney for financial with the trust. When you work with a lawyer and you have a trust and a power of attorney for financial together, banks and other people actually listen to you. If you say, oh, I took one of those powers of attorney off the internet and we executed it and I got it all properly notarized and witnessed, and now, I'm sorry, my parent's sick and I need to get access to the parent's bank account, and you go to the credit union with your 10-year-old power of attorney with no trust and nothing else, what do you think the first thing the credit union does? They tell you to go to court. It's too old. But if you have an attorney and a trust, they pick up the phone, they talk to the attorney that says, oh yeah, I drafted a trust, here's a copy of the trust. They are power of attorney, and by the way, not only is she power of attorney of this financial power of attorney, she's also a trustee of the trust, and once you put her on this, we're going to transfer that money into the trust. Done and done. No court involvement. Every time you involve court, you're talking about $1,500 to $3,000. Just started. So, it just doesn't make any financial sense to do it that way. A lot of times, and one of the reasons why I wanted to talk to this group, is that trusts are most important for people that own businesses. Because the stock that you hold, whose name is that in? Anybody have an answer?
In the trust.
How do you hold your stock right now? Who owns a company? Come on, half of you own LLCs and S corporations here, right? Who owns the stock?
The trust does, in my case.
You assign your stock to the trust.
Yes.
Very good. That's the way to do it. But No. When people walk in my office, we set up the LLC. I'm 50%, or my wife's 50%, or my 2 kids and my friend, he's 35%. It's all in individual names. Well, that is an asset in your name when you die that has to go through probate court. That asset has to be valued. It's attacked from creditors in probate court. And has to be assigned, valued. You pay probate court fees based on that asset, etc. All when, for a 1-page document, 2 lines long, I assign my interest in this stock or LLC to my revocable trust. Done and done. That's what we call proper funding of the trust. And, okay, let's say, Craig, I'm good. But what if you get injured? Okay? Let's say that right now you own 5 properties in your LLC and you end up in the hospital with COVID. You can't make financial decisions for yourself. Well, you say, well, I have a financial power of attorney for my spouse. That might work. If the financial power of attorney gives her power over your stock. But there are going to be banks that question those, guaranteed. But if you sign that LLC interest to your trust, and your wife or your successor trustee is the trustee of your trust, they can keep collecting rent payments. They can sell your property while you're in the hospital. They don't need permission. They come to a lawyer, I fill out 2 documents, I give them to the title company, and you can close. You don't have to go to court for a conservatorship and approval of sales or transfer of assets. It's all about saving you money by properly organizing everything. We talk often about taxes, okay? And the government's going to take all my money, okay? Right now, the estate tax limit is over $12 million for a single person. It's like $24 million for a couple, for estate tax, before estate tax hits. Well, I don't know about you, but that's 0.01%. I can think of one guy in this room that might affect. Okay, but the reality is, for 99.9% of the people in this room, we're okay with estate taxes if we properly create a husband and wife trust, allows transfer of assets to take care of the estate tax limit, etc. And then they say, oh, well, you know, we can gift money each year to save on estate taxes. For example, my wife has an uncle, he's my favorite uncle now. Every year, he writes my wife a check for $10,000. And it's part of his estate tax planning because when I started practicing law, the estate tax limit was $650,000. $650,000 was where it started. So, if he had more than $650,000, or 1.3 million, or 1.3, not a math major, 1.3 million, even if he had a trust properly set up, he would need what was called a second-to-die life insurance policy to pay the estate tax limit. Very common. That's how it was done. So you do a trust for the husband, trust for the wife, transfer as many assets as you can, pass down your $650,000 on the first death. Anything over the $650,000 goes into another trust to be held by the wife. Okay, but then upon her death, that's when you have to pay the tax. You just defer the taxes. Hope the tax laws change or whatever, and you have your life insurance to protect you, the second-to-die policy, which was a better policy and a cheaper policy than the first-to-die policy. But let's say you can only protect $1 million in that policy, and you had $5 million. Well, now you have an estate tax problem. So what you could do is you were allowed to gift $10,000 to any person you want every year, free of estate tax, and it doesn't go against your estate tax limit, it's called. We all have an estate tax limit. Well, that's great, but I don't believe my uncle listened to the lawyer properly, because he writes the check out to Craig and Nancy Federline. Half the time he mispronounces my name, okay? But he only writes it for 10 grand. He could write that check for $20,000. And he's not paying attention because the limit's now 17 and he can double that. So we really need to get him to talk to his estate planner. But the point I'm trying to And he's not going to talk to his nephew-in-law. You know, but, you know, all irrevocable trust. Can I sell that cottage? Yes. You can sell the cottage because I control the interest in it. So I can sell the cottage as long as I put the money in the irrevocable trust bank account. And I can reinvest it in a mutual fund in the name of the irrevocable trust with my Social Security number. Okay? I could also buy another asset. I can use and have the benefit of living in that asset. I just can't put the money in my pocket. So if you're trying to get money out of that asset, what do? You can write it to your principal beneficiaries, which, let's say, most of the time are your children, if they're old enough, and I usually don't recommend this for a trust unless you have older kids that you trust, okay? Then you can put that money into, you can write a check to those kids, and it's their money. They're the principal beneficiaries, and as long as the trust says that it's in your exclusive discretion, there's no judgment. Okay? Now, if you put terms and conditions in the trust, like it's subject to your health, welfare, then we call that an ascertainable standard. And then you're supposed to use ascertainable standards to give your money. So what we like to do is set up exclusionary discretionary trust, where your trustee has control of those assets and how to distribute those. And it's also excellent for creditor protection. We also do in our, a lot of people are concerned about maybe they have a child with a special need. Or they have a child, for example, that is a drunk or a spendthrift. We can set up purely discretionary trusts for them, where that you can put, let's say upon my death, I'm taking care of my special needs child while I'm alive, so I don't need to create that trust now. But upon my death, the special needs trust gets set up, and it's going to put, let's say, $150,000 into a trust for my special needs child, and it names who the trustee of that trust is, probably your other child, or a friend, or a lawyer, or accountant, whatever. And then they can use that money, as long as they don't violate the special needs provisions, okay, so that kid continue to receive government benefits. That's why we put assets in a trust. People can continue to receive government benefits. They can qualify for Medicaid, they can qualify for all these things, but we still have money for their other needs that we can pay for. Discretionary, but it's purely discretionary. Okay? What else do I need to say?
Describe government money.
Government money?
Yeah.
Government money, I'm talking about like Social Security disability payments. Or if your kid's already, getting some kind of assistance or need. So what we do is by putting that money into a sub-trust for your kid, it has full creditor protection. And with a co-trustee, they would still qualify for those benefits. Another reason why people do trust, even if you have minor children, let's say for the last 15 years I've had $1 million life insurance policy. Me and my wife die, my kids would have received that money in their sub-trust, okay? But the trustee would have been in control of that money. Well, if they were minors and now they're applying for colleges, do they still get grants and free money to go to college because both of their parents died and they have no money, even though they got $500,000 in their sub-trust? Yes, they still get paid by the government. They still qualify. If you don't have a trust set up, and there is $500,000 in the conservatorship at the probate court because you didn't set up a trust, guess when they get that money? 18 years of age. All of it. Subject to no control. Most of my trusts say kids don't get the money until they're 30 or 35 years of age. The money gets invested for their benefit, but the trustee has discretion to pay anything they want. They can give them money to start a business. They can pay their needs at college. They can do whatever they want in their discretion. But up until the age of 30 or 35, that money's fully controlled and protected for that child. I don't know about you guys, but I was still playing check to check until I was 30, 35 years old. All my law school loans. So the reality is most of us are not fiscally responsible enough until they hit a certain age. But if your kids are responsible younger, you can set that date at 23 years old, the date they exit college. Okay? There are trusts out there that typically, your average trust, I guarantee if you go home and you look at the trust that you have, you say, I got that, Mr. Federline. My trust says my kid gets, at the age of 23, they get 25%. At the age of 30, they get half. At the age of 35, they get all their money. That's true. A lot of trusts say that. But that's not a protected subtrust for your kid, where they control the subtrust at a certain age, name a co-trustee of their choice, and it's asset protected. That money and that trust says when they hit that age, they get a check, free of the trust, outside of the trust, and it has no asset protection on those dates. So every trust is unique and different. And so at our office, we provide a free consultation. We review your current estate plan, your current trust. What I typically like to do is I take a look at your trust, I look at your financial information sheet, we go and we make sure that your trust is fully funded, go over some of those assets, I read the trust, and then I ask you, well, what do you want when you die? What do you think this trust says? And then I tell you what it does say. And then we make sure that A equals B equals C, and it's actually what you want and what you need. So I wanted to talk about that power of attorney for financial a little bit longer if we got a little bit of time. Ed, I don't know.
Yep, you're good.
Okay. The power of attorney for financial is kind of like a blank check. Okay? It is effective immediately. We used to do powers of attorney that were only effective upon your disability. Because you're like, whoa, I don't want anyone touching my money unless I'm disabled. Good point. The problem is that requires banks to confirm that you're disabled. And do banks want to deal with liability issues? No. So now we do powers of attorney effective upon execution. You just don't hand that to the person who you name. You keep that in your binder of your book or your estate plan until it's absolutely necessary. Because it's effective immediately. But if I was to write you a blank check from my checking account, how much can you take out? Write you a check right now.
As much as all checking account.
Everything that's in the checking account, okay? Or at least that checking account. All right, but with a power of attorney for financial, it's a super blank check. It gives power over your stocks, your homes, buying and selling your real estate, power to fund your trust and to create an irrevocable trust, power to hire lawyers, power to handle your litigations and the lawsuits against you. And every power of attorney, my power of attorney is how many pages in length? It's more than 10, 15 pages. Okay? I've seen powers of attorney walk in my office that are 2 pages in length. Or 1.5. Guess what? When you go to Chase Bank and you want to use that power of attorney, they question everything. Including when I set up trusts for clients and we want to set up this irrevocable trust and they're like, no, you need a new tax ID number. We have to cite them law and say why and give them explanations. Okay? I guarantee your 1.5 page power of attorney that's 5 years old is not going to be accepted by that bank when you really need it. Because you didn't put a trust with it. It's all about having the right attorney, the proper estate plan, and working together. A perfect example is that healthcare power of attorney. I represented a brother. His other brother was dying. He had a trust, and we did powers of attorney for him for financial and healthcare. And his brother's goal was when he's sick, he had cancer, wanted to die in his home. Well, it was dating time for discharge from the hospital, and guess where they wanted to send him? Physical therapy nursing home. Okay? Be careful how they phrase that. But the reality is it was a nursing home, and he was going to die there. And why would they want to do that? Because they want to make
Their money.
their money. Exactly. So he said, oh no, I'm power of attorney for my brother. I get to make this decision. They looked at him like, yeah, right, whatever. Okay? Then he called me. I said, what do you do? I said, here's my card. I did this power of attorney for your brother. We have a trust. You let them know that you're the power of attorney. If they got a problem with it, they give me a call. Guess what? He was released to his home. He got to die peacefully in his home with care workers taking care of his needs. Without the proper lawyer, with the proper documents. That's only how you can get things taken care of for your family properly. I like to tell my clients, you have when it's a balancing act, okay? And the balancing act is the money for your children, not a Roosevelt trust, okay? And balancing that with the, you know, you gotta look at the monetary versus the family harmony, okay? You wanna make sure you balance that. Anytime a client comes to me and wants to give a different distribution to one kid versus another, I say, fine. It's your trust, you do what you wanna do. We have to make sure we do this very carefully, make sure we dot our I's and cross our T's, and make sure that the other kid doesn't drive you into my office and wanna sit in my conference room while you sign the documents. I actually had a case that I won for undue influence in setting aside a trust. Okay? It was a jury trial, lasted like 5 to 7 days, and it was because that trust was under his undue influence. Usually you have a case where you have a person with diminished capacity. You know, they're getting older, they're sick, they're not 100%, they might be relying on that person for care, maybe living in their house, and then what they do is they go to the lawyer's office and change everything to them. Okay? And those trusts can be set aside for undue influence if the proper safeguards aren't set up in that lawyer's office. It is possible we send you to, I've had to send clients to doctors and say, please come back to my office with a note from your doctor that says at least you're competent to execute contract documents or legal documents. Now, when you go to a doctor, typically they determine mental capacity, which there are lawyers that'll tell you mental capacity is different than, you know, capacity to sign a trust or a will. But when we start talking to a jury, they're not that different. If you take the appropriate safeguards, you get a note from a doctor that says he's completely competent to handle affairs. You actually go back to an independent lawyer that person pays for without you sitting in the room and giving all the information, and that person's able to competently tell the lawyer what they want. That's not going to be subject to challenge. And guess what? It's harder to challenge a trust because the trusts are private. You're not entitled to what's in the trust or to look at it. Okay? As a beneficiary, you would have to petition the court to try to get the court to look at the trust if possible. And if you're in error at law and you're not a beneficiary of the trust, you're out of luck. The trustee says, sorry, you're not in the trust. That's it. You get one letter back. What about accountings? We go to probate court for complicated accountings for the probate estate of the will. And the court requires us to do these accountings that makes every attorney rip their hair out. You've got to account for every penny and every nickel and every receipt. Okay? When you're a trust, do you have to give that kind of an accounting? No. You can say, here, beneficiaries, here's a copy of some of the bank statements and the investment statements, and here's a copy of my QuickBooks check register. Good enough? Probably. Probably. Okay? There's a different level. So with the trust, what we're doing is we're trying to avoid court. The key is avoiding court. Okay? There's no guarantee to avoid court. Any lawyer that tells you, I guarantee these documents are foolproof and keep you out of court, no. People can file petitions that are frivolous or have very little merit. They can still file them in court. And then you have to hope that a judge understands the law and makes the right decision. Okay?
How do you name a trust? Do you put the people's name in it, or do you keep it very vague so it's, if a house is in it, hypothetically speaking, no one even knows who owns that trust is?
Okay, so for purposes of a trust, if you want to keep it, you can use a trust any name you want. Okay? So you can have more than one trust. So you can have a living revocable trust, and you can have a joint trust with your wife. A husband and wife trust that's called the Federline Family Trust, let's say. Okay, that's my joint trust. But then I have a separate trust that's called Frankfurt Investment Trust. Well, the Frankfurt Investment Trust just holds my cottage up north. And that goes to different beneficiaries than the joint revocable trust. You can have more than one trust. You can use whatever name you want.
I have another question. So, a lot of people in this room, including myself, hold properties in LLC. LLC comes with a $25 a year filing fee to the state. could we flip the entire model and actually start owning all of our properties in the Frankfurt Investments LLC? I mean, Frankfurt Investments Trust, and just skip LLCs altogether?
I wouldn't recommend that because the trust still is subject to a lawsuit. Now, it would only be subject to those assets that are in the trust, like an LLC. You can have insurance for the trust just like you would normally. Okay, but
Wouldn't it almost be the same thing?
it's similar, okay? So you can do, and there are many, that's very common to do a cottage trust. Okay. Now, I don't typically recommend that.
Very good. Is an irrevocable trust really irrevocable? And is there some sort of road sign that you start thinking about going from a irrevocable to a revocable? Is there something that would push you over the...
Yeah, well, first of all, don't follow this road sign, okay? Because this is just for references that, those assets need to go in a trust. But it depends on what the purpose of the irrevocable trust is. But no, actually, if you're talking about that Medicaid irrevocable trust that I prepare, what you do is you maintain and get to be the grantor of that trust. You maintain control of that trust and the distributions out of that trust and the investment of those trust assets. Okay? So that's important. Let's say you want to take out, and you have beneficiaries of the trust are your two kids. And the trustee, the future successor, you're the trustee right now, but future successor trustee is one of your children. Well, you're getting up there in age, now you're 80 years old, you've exhausted the stuff in your revocable trust that you left there, your pension and your Social Security is getting really small. You know what, kid? I need $100 grand out of my $1 million trust that I protected for you. You write a check to that kid for $100 grand, kid puts the $100 grand in his pocket, and says, ha ha, thanks. What can you do about that? Nothing. But what you can do is, in the trust that I prepare, you reserve the right to amend that trust and change the beneficiaries and change the trustees.
What about the state land trust or normal trust someone in this room would have? And if you make it irrevocable, can you unmake it irrevocable? No! You undo the irrevocable part and go back to irrevocable.
The answer is, it's complicated, and you would need the permission of all the parties involved, including the beneficiaries.
Once it's done, it's pretty well done.
It's pretty much done, yeah. Now, I'm not telling you it's impossible, because it is possible, but it's not something that you would ever do or want to do, because it is something that, but like I said, you reserve the right to change the beneficiaries. And you could also, let's say you have that one kid who listens to you, you can pay that money to that one kid, he gives it back to you, and then you create a new trust.
So if you reserve the right to change the beneficiaries, hypothetically speaking, if you change the beneficiaries to one beneficiary, the one beneficiary is okay with you revoking it, and you revoke the irrevocable trust?
That's correct, but that is going to cost you a lot of money. But yes.
How much is a lot of money?
How much is a lot of money? You're looking at, my hourly rate's $300 an hour, okay? Your typical revocable trust, you're looking at around $3,500 for a trust plan.
Okay.
Irrevocable trust, you're looking at like $5,500. And then to revoke stuff, takes a little bit of research, and you're looking at about, a few grand.
Okay.
Now,
But if you got $1 million.
but the point is this, it's something you don't want to do, okay? I know this group is famous for asking questions that are off the beaten path, but the reality is it's something that you prefer not to do. So for example, you're in this group, you're an investment real estate person, and you put your money in a irrevocable trust. And then you go to the bank and you want to borrow more money. You can't do it. The bank's going to see the money's in an irrevocable trust. You're not the principal beneficiaries of the trust. You can't loan off of that investment. So you got to be careful that the money you put in that irrevocable trust is the money that you're not using. Okay? And do it at the right point in life and time of life.
I was going to say, Craig, isn't that the real key with the irrevocable trust is there's a time and a place for it, and it isn't something that you, like Ed wouldn't do something like that now. That just wouldn't be smart.
Correct.
But maybe when he hits 70 years old, he goes, you know, want to set this up?
Oh, typically, Ed could have a revocable trust and an irrevocable trust, and upon his death, he can fund certain assets into the irrevocable trust, which becomes irrevocable upon your death, except the joint trust doesn't. You still got your wife in that one. So let's say you have a joint revocable trust with your wife, but you have an irrevocable trust in your own name. Upon your death, you can take your life insurance policy, dump it into your irrevocable trust. Then that asset's 100% protected, not only from your wife as well. Did I just say you can X out your wife? Yes, you can with a trust. Nobody has an absolute right to your assets through a trust. I don't care if you're the kid, you're the heir, you're the spouse. You can be X'd out. Okay? That's
Greg, is there any credibility in the clause that they put in some trusts and some wills that say that anything we forgot to put into the trust is automatically included in the trust? Is that worth anything?
So, yes, it's helpful for miscellaneous personal property, and it's sometimes helpful in litigation with a general assignment. The problem is there's too many lines in the trust and other places that work against that. So no, the general assignment's okay, but you end up back in probate court to assign that if you're already deceased and you haven't properly funded the trust. It reminds me of we talk about creditors, and I brought up the spouse. So I always like to bring up this story I call the Biff story, okay? Upon my death, okay, when I die, I'm a pretty frugal guy. I still live in the same house that I did in 1999. Okay, my wife's always wanted a pool. I haven't upgraded the house. She complains it's too small. I don't have a pool. So what's the first thing she's going to do when I die and she gets the $1 million policy on all my assets? She's going to sell that house. She's going to buy a house with a pool. Well, what comes with a house and a pool? Well, Biff, the pool boy, comes with the house and the pool. Okay? Well, what is Biff and the pool boy going to do? Well, the first thing she's going to do is she's going to let him use my golf clubs. Okay, that's a no-no, just so you know. He's not going to be allowed to use my golf clubs, but he might be able to. Okay? And then, what happens after that? Oh, well, Biff realizes that my wife's worth a couple mil. You think Biff's going to marry my wife? Hell yeah, he is. And then what? Oh, wait, Biff's younger than my wife. Yeah, my wife doesn't have the greatest health. Oh, what happens when my wife dies? She can cancel my revocable trust and create a new will or trust with Biff. What are my kids getting? 0. It's called the second to die. We see it all the time. Most people that can't afford trusts or can't afford wills or lawyers or don't plan, their families fall to the second to die rule. The step family gets all your money. And I get calls constantly. People complaining, what can I do about it? Nothing. But there is something you can do today. If you want to avoid the Biff in your life, I have a remarriage provision in my trust. So I have a joint trust with my wife, okay? But it says if she remarries, she's no longer entitled to A, revoke the trust, or act as trustee. And then my kids can determine whether she gets some of the money. Okay, so there are provisions we can put in a joint trust to protect against that, because trust me, every husband and wife that walks in my office, I'm always looking at both of their eyes, making sure that they're on the same page. Okay, and they're not always on the same page, but they want to have their assets together. They want to take care of each other's for life. They want that joint trust, which makes a lot of sense when your assets are less than $5 million. We put it in a joint trust. It's easily funded. It's simple. Okay, first death, you really don't have to do too much. A lot of my clients want a joint trust, and it makes sense. They want to take care of each other first. That's what me and my wife want. But what if my wife determines to get remarried and do things that we haven't talked about? Well, the trust can provide that remarriage provision. You can also put a provision in your trust that if your kid doesn't maintain a 3.5 grade point average, he gets nothing. Or a pure discretionary trust where the trustee gets to decide if your kid gets a penny until they reach a certain age. Or you have a kid who's a problem and you only want that kid to get $300 a month for the rest of their life plus cost of living adjustments. Okay, go ahead.
So what happens if during after death, what happens if the trustee dies?
That's why we name alternate successor trustees, plus my documents about this thick, which lays out provisions on how the beneficiaries and the trust protector, such as myself or another lawyer you put in the trust, can name a new trustee so we don't have to go back to court. It gives beneficiaries the power to remove trustees if possible, depending on if you want to give them that power. Like, you can say, the majority of my beneficiaries in my trust can remove that trustee. As long as that provision is there, then you have that power. But you always want to name several.
The other thing I heard recently in regards to the 5-year rule and the Medicaid and the nursing home, for some people, it doesn't even really come into play. Number one, they won't be there that long. And number two, they have sufficient income from Social Security or a pension plan that's going to pay for the nursing home. So it's like, don't even worry about it.
Well,
Is that fair?
so that is a fair statement, okay? You could, let's say I have a client that comes in and they have a long-term care policy that would pay for their nursing home. Well, don't need a Medicaid asset protection trust, do you? No. You might want an irrevocable trust to protect your life insurance policy if that injury with the car accident I talked about. So you still might want that trust. Okay? Now, but in a lot, I've talked to financial planners actually that have come to this group, and they're like, well, I don't like these irrevocable trusts, Craig. They're confusing, they're a pain in the neck, they're a pain to deal with the financial planners, and he's correct, it's not easy. Okay? And he says, well, most of my clients don't need it. And I'm like, okay, what's the number? What is the number? So if it's, I'm not a financial guy, but if let's say the number for a nursing home is $10,000 to $12,000 a month, I guess if you have $2.5 million and making 10% interest on your investments, you can cover it. Right? Then there's your number. But majority of the clients that come in my office have $1 million or less. And if someone enters in a nursing home, and with dementia these days, people are spending longer and longer in nursing homes, okay, then you have a problem. So it's only about protecting some of your assets. I'm not throwing, the one thing I think I made clear here is don't throw all your eggs in one basket. I told you you need a revocable trust with a living wage and livable assets in there, okay? But the reality is you take your other assets that you have and you protect those assets. If you can, and if you don't need them, and you're at that age. Majority of my clients that are 70 and older, that come into my office, we go over a budget with them. Guess what? Most of their incomes are not going down, and they're living off their Social Security and their pension that's coming in, and they're just pretty frugal. So why not put your money in an irrevocable trust if you don't need it? And if you do need it, and you trust your children, you could write a check to them for any time you need to take money out of them. Because you know what? You can't. Failing to plan when you can is the problem. We want to plan when we're vertical, not horizontal. And that's what I find is people wait too long to plan. So get your plan set up and fund it as you need the right time. Go ahead.
Greg, I really, the board wanted Craig to come in and talk because at our last board meeting, we were having a conversation. And Craig really hit on a lot of things that he sees every day as an attorney that we don't think about. And one of the things that he talked about is where the first spouse passes away and everything that people work for, the spouse meets somebody and all of a sudden the original family and kids that were the intended recipients end up getting just wiped right out. Right? They don't get taken care of. Because somehow, this, like the story he was in, the first spouse passes, the second spouse remarries, younger person, then they pass. Now the younger person gets all the benefits of the two that started the family, and he sees that every day. So that's a lot of the importance of what he's talking about is you got to think how you want your money to be distributed and you're not here, that's what he's talking about. Setting that up, trusts, making sure that what you want to happen happens. And that's how he.
They don't lose their assets, okay? Let me know what you care about. You come to my office, you have a free consultation if you come to my workshop. We go over your assets, okay? And from there, after we do that, then you decide whether you're going to retain me for whatever the cost is, okay? Most of my services are flat fee based, okay? And then, after we do that, then you come into my office again and we hold what's called a vision meeting, where we envision what your trust should be. Do you want a joint trust with your wife? Do you want an irrevocable trust? How do you want it to go? Do you want the remarriage provisions, or, you know, what if your kid doesn't maintain a grade point average? Do you have a kid with a special need? We go over all the possible options that exist for you. We vision and create your trust. Then you come in and you sign the trust documents for another appointment. Then you come in a couple weeks later and you come back again, and now we talk funding of the trust. Because the whole time you're giving me information on your assets. Okay, and then once we create the trust, now we have to fund it with all the important stuff. Because what is the good of doing all this if you end up in probate court, wasting another $3 to $5 grand in probate court, when you paid me to try to save you some money too? Although trusts are not cheap, okay, they are affordable and they provide a protection that is necessary as part of your financial planning. All right, so thank you for your time today. Feel free to give my office a call. You have the website. We're located right downtown in Court Street. And if you need information, you can contact this association or my office. Thank you.
Thank you, Jeff. And one of the stories that we were sharing that I believe it was a story about my Uncle Lou. And my Uncle Lou was married to my Aunt Sharon. They were married 35 years or something like that, and she passed of cancer. And he lived up north in Lewiston, and Lewiston's a lonely place to live. And so he was on the online dating and predators overseas and all sorts of stuff, wiring money to Cambodia for all I know. And it was a disaster. And he ended up remarrying this old lady, and the old lady's kids brought attorneys to the house, had a new will drafted, house ladybird deeded to her, and stole everything from my uncle's kids, Don and whatever the other guy's name was. So this scenario, it happened to my own family. And inside of this house was 89 of my grandpa's guns. And my Uncle Lou was a stubborn old fool. And he wouldn't let any of the heirs to those guns in the house until after he passed. Well, I went up there to retrieve the guns, and there was 3 left. 3 out of 89. So those stepsons really made out. So definitely to CCF Legal. So we do have a form on everybody's table tonight. And this is a sign-up form for the Landlord Association. I think we've got 4 guests in the room. So thank you guys for coming out tonight. Membership for new members now is $197. And since you're at the meeting tonight, we do an in-person meeting price of $147. So if you would like to become a member and not pay the price of $197, you just draw a line at the bottom where it says $197 and write $147. And Amanda and Linda in the office will be sure to get you guys set up. Amanda will be here after the meeting. If you have any questions, I'll be here as well. Thank you guys for coming out. You know, it was a blessed night. $50-50. 6383 is the last 4. 6383. $35 hairs. Is anybody still here with that ticket? Bueller. Who here has seen Ferris Bueller's Day Off? If you haven't, get on it. 6383. We got a winner? Excellent. Thank you.
Who's got it?